A settlement agreement is a written contract between an employer and an employee. They used to be called compromise agreements until 2013, but they're the same thing. They were just renamed. It sets out the terms on which an employment relationship will come to an end. In some cases, the employment relationship might have already come to an end. And the key terms will be that the employer pays a sum of money to the employee, and the employee agrees to waive their right to claim anything further from the business and draw a line under the relationship. There will also be various other terms as well which aren't financial, such as terms as to confidentiality, a prohibition on either party making derogatory comments about each other. The idea of a settlement agreement is it brings finality to the relationship. Both parties can move on and draw a line under things. There are probably three main scenarios in which an employer might want to use a settlement agreement. The first is in redundancies, potentially to shortcut the usual redundancy consultation process or as a condition of an enhanced redundancy package. The second is where there are performance or conduct concerns in relation to the employee in question. If the person isn't right for the business, it might be appropriate to talk settlement terms as a consequence. And thirdly is where an employee has raised a grievance or made some allegations or brought a claim. Reaching a settlement agreement to resolve matters might be something that's in everyone's interests. There are really three costs you need to account for. The first is the cost of the severance package that you would like to offer or agree with the employee. Usually that's going to be made up of several parts, some of which the employee is entitled to anyway upon their employment ending, such as holiday pay and notice pay. But it will also include an ex gratia element or compensatory payment, which is effectively the sweetener for the employee entering into the agreement. Second, you've got the employee's legal fees, or at least a contribution towards them. It's customary for the employer to make a contribution, usually in the region of £500 plus VAT. And that's because the employee has to take legal advice in order for the waiver of their rights to be binding. And thirdly, you've got your own legal costs incurred in taking advice on the situation. These costs can add up, but they need to be weighed against the alternatives. And in a lot of cases, it can make good commercial sense to offer or try and agree a settlement agreement. The answer to this can vary hugely from case to case, and it will depend mainly on your negotiating position and the alternatives available to both parties. Let me give you two examples. The first is where you follow a redundancy process. You're confident that you've followed a full and fair redundancy process, so the risk of a claim is low. If you want to offer an additional payment as a gesture of goodwill to the departing employees, then maybe that payment would be set at just a few weeks' pay to give them some financial support as they move on from the business, even though there's no real obligation to do so. A much different scenario would be where you're proposing exit terms, where you don't have a fair reason to dismiss the individual in the alternative. In that type of situation, we'd probably be looking at a payment of several months' pay. But where we end up, as I say, can vary hugely from case to case. Like any agreement or contract, it depends on how long it takes the parties to agree. In simple cases where the parties want to agree as soon as possible, it can be done in less than a week. The individual has to, of course, book an appointment with a solicitor so they can take advice. So it's not going to happen immediately, but it could happen within just a few days. On the other hand, we sometimes see settlement agreements taking weeks, months even, but these cases are relatively rare. The aim of a settlement agreement is to bring things to a mutually agreed resolution and promptly, and that's what we see in most cases. We offer a free initial chat for all potential new clients, so do give us a call in confidence to see how we can help. We're happy to talk through the situation, look at what your options might be, and run through our costs, all on a no obligation basis.